Hey everyone, this is Zach, the broker for Zach Taylor Real Estate. So today I want to go over contract deadlines and what it means to default. So this video is meant to be very serious and kind of show the severity of these real estate contracts. For most buyers and sellers, this is the largest transaction of their life. So there's a lot on the table and we don't want to be subject to potential litigation, going to court, being sued, or losing our license. The fastest way, or one of the fastest ways to lose your license as a real estate agent is to forget contract deadlines, get sued, owe damages, have to use your errors and omissions insurance. Hopefully it covers all the damages, and then you lose your license with the state. So that's why today I want to show the severity of going over real estate contracts. There has been a common misconception, and I heard this recently, and I want to show that it is even more serious than what they thought. They thought, hey, if my buyer misses out or I messed up, they just lose their earnest money, or maybe I just have to reimburse them for their earnest money. No, the earnest money deposit is a credit towards the total damages for the seller or vice versa. So I want to go over first the severity by showing the default. Then we'll go into contract deadlines that are actually in this contract. So default, if you go to line 390 of the purchase and sale agreement, should the buyer default hereunder, the earnest money shall be forfeited as damages to the seller and shall be applied as a credit against seller's damages. Seller may elect to sue in contract or tort for additional damages or specific performance of the agreement or both. So that earnest money is not the only thing that they could be on the hook for. If we miss deadlines, or if we tell our client, hey, you have till tomorrow for your inspection period, but actually it ends today, and they couldn't terminate in time because we told them the wrong deadline, guess who's on the hook? We are. So we need to protect ourselves and protect our client. Further, it keeps going. Should seller default, buyer's earnest money shall be refunded. Buyer may sue in contract or tort for damages or specific performance or both. It also says the prevailing party shall be entitled to recover all costs of such enforcement, including reasonable attorney fees. So there is attorney fees, there's specific performance, forcing somebody to either buy or sell the house, plus the earnest money. And there's a concept in the legal system that's called treble damages. Certain statutes require that after the jury has determined the amount of plaintiff's actual damages, the court must award 3 times that amount. So suddenly, if you had a $500,000 home, we missed the inspection deadline. We told them, hey, you have 11 days, even though it was only 10, $500,000 purchase price, $2,000 in earnest money. It's not just the $2,000 we could be on the hook for. It could be the seller sues them, forces them to close. That's a $500,000 purchase price. Treble damages makes it $1.5 million plus attorney costs. So we don't want to be on the hook for $1.5 million. Treble damages, the purchase price of the home. We want to take this extremely serious. The first thing I do when I have a contract that is now bound, if you're not sure what bound contracts are, or the binding agreement date, that's the date when everybody has signed and all parties have copies. Watch my previous video if you don't know what that is. Once I have a bound agreement, I'm writing every single deadline in my phone, in Google Calendar. I'm also sending an email to my client with all the deadlines. That way they are aware ahead of time. If you don't know or you need help, hire a transaction coordinator. It's a couple $100. Almost look at it as insurance that they will help you as well maintain the deadlines within the contract, make sure your client is in compliance. Also get with your broker. If you need help with your contracts, or this is one of the first times you're filling out a contract, get with your broker. We would much rather help you before there is a problem. So get with us ahead of time. A court system is not going to look at, well, I was just too busy, or I was working too many deals, or I forgot, or I just didn't think about it. Whatever the reason is, the court system is not going to care. If you misled your client, if you did not adhere to the contract, you will be on the hook. So none of those are valid excuses. And the other thing too, as a broker, and I'm not calling anyone out, I'm here to help everybody. But when you call with a contract question and I say, well, when did your inspection deadline end? And you say, well, I don't know. Or, well, when was your binding agreement date? I'm not sure of that either. I know we're in trouble. You need to know your deadlines like the back of your hand. You need to memorize those because this can be very, very serious. So now that we understand the concept of defaulting in this contract, we need to know, when do deadlines actually end? Before we jump into different types of deadlines, well, when do they end? So if you scroll further in this contract, line 429, in the event of a performance deadline other than the closing date, date of possession, completion of repair deadline, and offer expiration date, other than those four things, in the event of a performance deadline, if it occurs on a Saturday, Sunday, or legal holiday, the performance deadline extends to the next following business day. Now, just because it extends to the next business day does not mean it ends business hours. 11:59 p.m. it still applies if it's pushed to the next day. You can look at this attorney response from the Tennessee Association of Realtors. Correct. In the event of a performance deadline rolls over, it will still be 11:59 p.m. the next day. So that is when they end. If you're curious when a holiday is considered, Google 5 USC 6103 and you'll see all federal holidays. So this is when they actually end, 11:59 p.m. Now, let me go over some of the biggest ones within this contract. So the first one that I want to point out is the earnest money deposit. This is the good faith deposit. You'll see 3 days here, 5 days, 7 days, whatever it is. This is one of the biggest deadlines up front. If you have 3 days, make sure your client gets their earnest money deposit to wherever it needs to go within that time frame. That's the first one you should be aware of, earnest money deposit. The second one is going to be inspections. So a lot of contracts have inspections. So you could say, hey, we have a 10-day inspection period. We have a 15-day inspection period. But whatever is here, your client within these 10 days, within the 10 days, must have all inspections done and notify the seller within those 10 days what their decision is. Are they going to terminate? Are they going to accept the house as is? Or are they going to give the seller a written list of items which buyer requires to be repaired? And now you move into what's called the resolution period. So that starts the clock on a new deadline. So within the 10 days, it's not we have 10 days and then automatically, if we have a resolution period, we just automatically go to resolution period. No, we have to give them notice of things to be repaired within this 10 days in order to start the clock on this. If we hit day 11, then notify them, we're out of luck. So make sure you know that deadline as well. The last big one I want to point out is the appraisal. So if your agreement is contingent upon the appraised value equaling or exceeding the agreed upon purchase price, if it does equal the purchase price or it's more the appraised value, this contingency is satisfied. If it doesn't, if it appraises under the purchase price, you have to notify the seller via the notification form, and then the buyer has 3 days to either move forward or terminate within 3 days, not 4, not 5, within 3 days. So it's very, very important. We know our deadlines. A form created from Tennessee Association of Realtors. This is a good one to use if you need further help. Writing down in your phone, on your Google Calendar, sending out an email to your client, but you could also use this form, Purchase and Sale Agreement Timeline Checklist, RF 708. So it goes through even more deadlines within this contract. Within 3 days of the binding agreement date, remember, watch my previous video if you don't know what that is, verify that the loan application has been made, lender has been instructed to order credit report, buyer has paid for credit report. That's within 3 days. Within 3 days, notify seller of date of application and lender's name, contact information, and that lender has been instructed to order credit report, buyer has paid for report. Within 14 days, buyer has requested that the appraisal be ordered and the fee has been paid. Within 14 days, provide seller with representation and warranty of securing evidence of hazard insurance, so like homeowners insurance. Now, it goes over if the buyer isn't adhering to the timelines, the seller can make demand for compliance that, hey, you're not following the contract and you have to now do these things or else. Within 5 days, buyer to provide proof of funds for when financial contingency is waived. Within 5 days, buyer to provide name and telephone number of appraiser and proof appraisal was ordered. Appraisal complete, appraisal received. It also goes into inspections. If you have different contingencies thrown in there, homeowners insurance, possession, stuff like that. So use this form. TAR usually has a lot of the forms we need. The final points I want to make to help agents stay out of trouble. One, like I said, know your deadlines. Know them like the back of your hand and help your clients stick to them. 2 is, and this sounds a little negative, but no more handshake deals. No more good faith negotiations, no more verbals. Maybe you call the other agent and say, hey, we need to extend our inspection period. it's day 10, it's the last day of your inspection period, and the other agent tells you, oh yeah, we'll sign that extension, just go ahead and send it over. The seller's busy, they're out of the country, they're working, we'll get to it tomorrow, but all good, we're good. And you take their word for it. You wait till the next day. It's now day 11. I have seen where agents have done a complete 180. That listing agent will call you day 11 and say, actually, we changed our mind. We're not going to extend it, and now you're accepting the home as is. It happens. So do not take just good faith negotiations, handshake deals, get it in writing. That's the third thing. Know your deadlines, no more handshake deals, get everything in writing. Now, when I say in writing as well, there's been a misconception that text counts, and it does not. A text does not count. So when you go in the contract as well, and you go notices, could it be added in the future text messages? It probably will be, because text messages, you can see a date and time. But for now, according to the Tennessee Association of Realtor Purchase and Sale Agreement, notices, except as otherwise provided herein, all notices and demands required or permitted hereunder shall be in writing and delivered in person, overnighted, fax, the United States Post Office, or email. So those are the 5 ways that notice is given in writing. It can't be verbal. It's got to be in writing. And furthermore, it can't be a text message. So if we get to, let's say, same example with the inspection period, that's just the easiest one. It's day 10. It's the last day of the inspection period. And you text the other agent and say, hey, we're going to terminate this contract. Buyer found there was a water leak under the home. We are hereby canceling the agreement. That's through a text. Get to day 11, the listing agent is going to notify you and say, hey, you guys are not moving forward as is with the home. And you say, wait a minute, I sent you a text, we canceled the deal. No, text does not count. It needs to be email, in person, overnight, fax, post office. Those are the way to give notice within this contract. So that's why I've said with another agent, don't just go based on their word. That's how you get in a lot of trouble. Even if they say, well, this is the way we've always done things, or in 10 years of doing it, this is how I've always done it. Don't do it. Rely on your training. Rely on what your broker is telling you. And further, the last thing I'm going to say with this, and it kind of ties into what I've been saying already, take control of your contracts. Take control. So again, another example, let's say a closing date is coming up. You represent the buyers. Closing's supposed to be tomorrow. You know they're not going to be able to close in time. The lender needs more time. They say, actually, we need till next week. Call the other agent. You say, hey, we're going to have to extend. The other listing agent says, hey, that's fine. We'll extend next week. No problem. And you send an extension over. The listing agent says, hey, we're all good. We don't have to sign this. And you just go with it and say, okay, that's fine. As soon as you're out of contract again, that agent can flip, do a 180 and say, oh, you guys didn't close on time. Somebody's in default. You don't want to do that. So take control of your deals. You know the deadlines. You know what happens if you default and the severity of it. You know how to give proper notice. Don't run into legal issues. Don't create more legal burden on yourself. Follow your deadlines. Do everything in writing. Let me know if you have any questions. I will post a link below to speak with me directly. If you guys need anything, let me know. The last thing, I did forget this with notice. So when you give notice, notice shall be deemed to have been given as of the date and time it is actually received. There's a lot of confusion with this. So remember, it's 11:59 p.m. is when all the deadlines end. So let's say, again, I'm going to go one more time back to our inspection deadline. We send notice at 11:58 p.m. via email that the buyer officially terminates. There was that water leak under the home. Day 11 comes. The listing agent opens their email on the 11th day and says, well, wait, I actually received it on the 11th. So no, you guys didn't qualify to terminate in time. Wait a minute. Actually received. Like it said in the notice, time it is actually received. It is not when the listing agent has actually opened it. Once a document hits your inbox, mail, it is considered received. It does not matter when the email was actually read. So as long as you sent that email, 11:58 p.m., you are still good that your buyer wanted to terminate that contract. So again, if you have any questions, reach out below. Until next time, I'll see you guys.